All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
You may be seated. Glad to have you all here today. Chief Justice Parker is unable to attend this oral argument today, but he will review the recording that will be available for him. Justice Jay Mitchell is participating remotely. We also welcome all of our special guests today to this argument. So, Madam Clerk, if you would please call the docket.
In case number SC 2023-0740, Crystal Kaye Coan v. Championship Property, LLC. Arguing for the appellant, the Honorable Kenneth J. Lay. And arguing for the appellee, the Honorable Jim Ingelthaler.
Mr. Lay.
Mr. Chief Justice and Associate Justices, and may it please the court. My name is Attorney Kenneth Lay, and I represent Crystal Coan in this case. This case arose out of what was originally an ejectment suit that was filed on June 12th, 2018 by Championship Properties. And what brings us here today is a contempt order which was entered by the Circuit Court of Lauderdale County on June 28, 2023. We filed this appeal on July 10th, 2023. This case began, as I said, in 2018 with an ejectment suit filing. Thereafter, we represent Ms. Coan, and we filed an answer and a counterclaim, and we added third parties. This is a case where it arose originally out of a foreclosure. There was another ejectment case, as I noted in the brief, that was filed by the foreclosing entity by Carrington and Bank of America, but that case was dismissed when they sold the property during the pending litigation to Championship Properties, and that's what.
Mr. Lay, is Carrington an indispensable party in this case? Because if the mortgage is set aside like you're trying to do on the bigger case, wouldn't they then step into the shoes of Championship?
No. Judge, I don't think they're an indispensable party. When we've had these cases, one that went to the 11th Circuit, the bowling case, that was similar, the same setup with a third party and bringing in the foreclosing entity. I don't think they're a necessary party, but what the court ruled in the 11th Circuit in the bowling case in 2020 was that when we bring in a party as a joined party, not necessarily as a necessary party, they are listed as a counter defendant in the case. I believe we could defend this case if we had not even brought in parties. There are other cases like the Campbell case, for example, that's cited and has been cited by this court and was cited in the briefs, where a foreclosure case that was similar to this. There was not a counterclaim filed in that case. There was not a third party brought in the countersuit. So I don't think it's a question of a necessary party, but it makes it more difficult if that party is not involved, especially when you have a third party transfer, as we do in this case, because
I guess that's my question. Is Carrington involved in this litigation?
yes, Carrington and Bank of America were brought into the case. And just for the history, because I'm sure some of you are sitting there thinking, why is this a case from 2018 and we're here in 2024? I'm sure that's come up. So let me, what's that?
We did have a.
Yes, we did, but actually this actually started before the pandemic. So what happened in this case is once we filed, and I actually addressed this about the delay in the reply brief because I want to make clear we often get accused, and I understand why, of being the delaying parties here, but we were not in this case. And what happened is once we brought in the bank and as the counter and Carrington, Bank of America and Carrington, they chose to remove the case to federal court. And the Appellee's championship agreed, and they consented to that removal. They did not have to do that. And that is what caused the delay, about 5-year delay in this case, was it went to federal district court during the intervening period. As you said, we also had COVID, but the bowling case came out on the heels of the Home Depot case from the U.S. Supreme Court, which held that you could not remove cases where there were third parties added in the countersuit like we had done. So Judge Heikkila sent the case back to state court on the basis of the 11th Circuit decision in the bowling case. We had a couple that were waiting on, and she then had told us that that's what was going to happen. So she did, and they appealed. The banks, both Carrington and Bank of America, chose to appeal that to the 11th Circuit, where it sat for about 2 years. And ultimately, the 11th Circuit affirmed Judge Heikkila and sent the case back to Lauderdale County. Had the case not been removed, we were set for trial from October of 2018, and it would have been in February of the following year.
So I saw in the transcript of the contempt hearing that there was a discussion by Judge Self of a trial setting in the fall of 23.
The recent one.
Yes.
Yes, that has not happened.
And is that because of his status, the judge's status, or is that because of this contempt finding, or what happened?
I'm not sure that I can technically answer that because I'm not privy to his actual status. I mean, I know what I've read and heard, but I don't know officially. But I would say that my understanding was that he put the case on hold before all of that happened because of this appeal. And that there was a question on jurisdiction that the court had raised in this case about whether or not it's final. And I've had several of these, and I understand the concept of everything has not been decided in this case. But what brought us here was the fact that a contempt finding was entered in the case, that according to the case law, that is the avenue of appeal. My client was set out of the property even though there was no final order in the overall case on July the 13th, even though we had appealed the contempt finding.
But you didn't stay it. You didn't put a bond on.
We did not have time to get a stay or anything like that.
So let me ask. I think jumping. My concern is, if we agreed with you that the contempt remedy here was improper, the ejectment was improper, what do you think we should do at this point?
Well, and that's a very good question, and we weren't invited to do this, but I feel like you should know because this is part of the problem, and we're hopeful that the court will finally deal with this issue. I have been trying to have it addressed for almost 10 years about these cases where these orders of paying rent into court are entered. We consistently...
Let me stop you there. Number one, there are trial courts that have done this. Judge Self is not the first one that's done this.
No, he did it a little... This is the first time, and I do a lot of this work, you know that.
I know that.
Some of the other judges here know that. I travel all over the state. What happens is there are courts in some counties that do these types of orders. There are some courts in other counties that don't, even at the same time. I even attached, if you've seen the record, one from Mobile that happened almost the exact same time that this one happened in the Brewer case, where the judge in Mobile chose not to do it. One from Winston.
So the step of the order to make her pay money into court, that step to me seems like an injunction. Would you agree with me?
I agree that that's the closest thing that there possibly is.
It's an order by the court for her to do something. It seems like a preliminary injunction to me.
Yes, and it's never been treated like that as far as following the rules. That's part of the problem.
But you didn't appeal the preliminary injunction timely.
we have, because I've tried that before. 10 years ago, we had a case in Mobile where we tried to appeal. I did a mandamus on this very issue, and the court on a...
But you don't mandamus injunction orders. You appeal injunctions, right?
Well,
I'm sorry, I've got you off on the rabbit trail. I'll just tell you
I'm
where
not
I
sure
am.
what it is, because it's a really strange creature, and no one has really ever definitively, certainly the trial judge here never used the word injunction or anything like that. And the problem that we have with this, and it continues to be a problem, this is the first one in 10 years that I've had that's gotten to this level, where someone has been literally set out in the middle of the case.
See, but I see 3 steps here. Number 1 is the order to pay the money. Is that
Yes.
proper or not?
And we don't
I
believe
view
that's
that
lawful.
as a preliminary injunction, and you didn't appeal it, so I think you've waived that. Then is she in contempt? I know you disagree with me, but the record's pretty strong that she's in contempt to me. Then we get to the remedy. I've got a real problem, and Appellee can address this when they get up, but I'm just not certain how the judge has the power under contempt to issue ejectment. It seems like that's a default judgment in my mind.
It basically is, and the problem that I was getting to when we started this series of questions is the appellee, not only have they taken possession, because I've had cases like on appeal, we had one...
Right. What's the remedy, though, Mr. Lay? I mean, if we agree with you that this doesn't fit civil contempt or criminal contempt, and she's already been ejected, are we supposed to take the possession away from the foreclosure deed holder and give it back to her? I mean, I'm trying to understand what you think we should do if this remedy was wrong, other than reverse the finding of a contempt and send it back for the judge to figure out what remedy he should have for contempt, or should we just order a trial, or what do you think we should be doing if we agree with you that the remedy here, not the finding of contempt, but the remedy was wrong?
I'm not sure, and that's the problem that I mentioned when we started the case in Lauderdale County, that when you set up this procedure, it creates a horrible mess. And what's happened here, and he can address this, but they've already not only taken possession of the property, and they didn't just keep it status quo, they have actually made alterations and rented it out to somebody. So I'm not sure she can even be put back in possession. And that's part of the problem. I asked them not to do that. I sent a formal letter to their counsel explaining that this was a problem, and this is where we are today. And not only that is a problem as a remedy of contempt, the other problem is he didn't make a finding that there was anything willful in the order of contempt, which is required under Ex parte Ferguson. He also did not put in the order how she could purge herself of contempt if it was civil. I mean,
Isn't that the question, whether this is a civil or criminal contempt? I mean, there's certain things you can do. I mean, what in your view do we have? Is this a criminal contempt or is it civil contempt?
You know, and that came up. He threatened her, I'm sure you've seen the order, with putting her in jail, and we were very concerned about that. And I don't think he has the authority to do that.
So how do you view this? Is we looking at criminal contempt or civil contempt? Because they have
I don't know, and that's part of the problem with these orders, is not only what is, I've seen it treated 2 ways. This is a few times they have actually raised the issue of contempt, which is what happened here. The other thing that has come up when there has been a, quote, violation or somebody hasn't paid is going under Rule 41. But that procedure did not happen here either. And so they didn't follow Rule 41.
But you're not the plaintiff, so Rule 41 is about dismissing cases.
Well, it can't.
You're the
well,
defendant.
And I agree with you, but it's been used against a counter defendant.
Ah.
I mean, a counter plaintiff, I'm sorry. So
Mr. Lay, when you look at the contempt rules, and there's a series of really clear opinions from the Court of Civil Appeals by Judge Donaldson on how you analyze this. So a civil contempt is going to be a position where the judge says, I'm going to hold you in contempt, but you have the opportunity to purge your contempt. And the criminal piece, of course, is something that's in the past that the judge chooses to say can't be cured, and then the available punishment under the rules is 5 days in jail or a $100 fine or both. So, I mean, I understand what your position is as far as the whole contempt proceeding, but I'm still not very clear on what kind of contempt you're trying to say this is.
Well, Judge, I don't know. That's the part of the problem. They never said. He treated it like criminal contempt because he threatened her with jail.
Mr. Lee, you understand, we're going to have to issue it.
But he didn't actually give your client jail time.
No, but he never said it was criminal or civil. We don't know what he was proceeding under. I argued several different things in the brief because we don't know what it was. We were never told what it was. All it was it was a contempt. It was called a motion for ejectment. It was called a lot of different things. It was called a sanction hearing. And I'm sorry I can't give a better answer, but that I was guessing from it too. And I think that's part of the problem here. There's been no consistency. There's been no formality to it. And, you know, it's turned into an utter mess. And so now we're going back to court to argue the underlying merits of the case. And we have my client outside, you know, is no longer in possession and may not can get back in possession even if we were to win the case.
Wouldn't you concede that your client contributed to the so-called mess because she indicated, it looked like to me, that she could make the payment, and she failed to make the payment, and she put herself in contempt? So doesn't she bear some responsibility? She's not just an innocent bystander that was thrown out of her property, right?
No, I agree that she's at fault for not having the money and for not having the ability to pay. What she said at the hearing was two things. She did not understand that she was required to pay this. They filed this like 60 days after the first payment was missed. And she said she wasn't first aware of the order. When she did become aware of it, she was trying to pay, but she could not pay the full, I think it was $3,400 at that point, but said she was willing to catch it up. But you know, that I don't think that's willful behavior, and that's why I disagree with you, Justice Cook, that whether she was actually willfully in contempt. Not having the ability to pay is not the same as being in contempt. She's in violation of the order. I agree with that. But whether she was willfully and in contempt for just thumbing her nose at the court, ability to pay and having the resources to pay is not contempt.
When is the last time your client made a payment on the mortgage?
The last time would have been before the foreclosure, which was in December of 17.
December of 17. How long did your client reside in this property without making any type of payment?
Well, there was no order for her to make a payment until...
When you sign a mortgage, when you sign a contract, you were going to make payments. It says, here's your payment. I'm going to make this monthly payment.
Well, after the foreclosure, she cannot pay anybody legally by law. There was no order from any court, the federal court or the Lauderdale County Circuit Court, for her to pay anything until March the 8th of 2023, and she did not.
She could have paid the property taxes, right? And she didn't pay the property taxes either, right?
Well, no, actually you can't, because if the wrong person, and there's case law about who can pay property taxes, and no, she cannot legally pay them. I guess she could have gone down there and paid them. I mean, I understand. That's why I pointed out at the beginning, this 5-year period, it looks bad, and it looks bad on paper, and I understand that. I'm here before you. I get it. But it's not something that she purposely did or caused. In fact, it was actually caused by the Appellee by agreeing for it to be removed to federal court, which was not legally possible.
And then there was an order in
Yes.
23 to make payments, and payments be made into the court.
Between March and May, when this started.
And no payments were made during that time.
Those 3 payments were not made. We do not dispute that. We do dispute.
Even though she had, at that point, 3 or 4 years to be saving money to make.
Well, and as you saw, you know, her son was diagnosed with cancer. She lost her job during COVID, caused her to get on drugs due to depression. And I mean, there was a series of unfortunate, then the aunt, you know, got brain cancer. So I understand what you're saying. And yes, the order was there. And yes, she probably should have paid it. I'm not sure that she could pay it at the time. And that's our
Mr. Lay, your red light is on.
yes,
Have
it
the
is.
justices completed all of their questions?
Is there a trial date?
There was in September, but again, it was canceled due to this appeal. And in fact, we were in the middle of summary judgment when he stopped everything, and then the other stuff happened. So I don't know if it's presently set.
Thank you, Mr. Lay.
Thank you, and
Madam-
appreciate the opportunity.
Madam Clerk, we went over a little bit. I'll just rely on you to adjust any time. Thank you. Mr. Engel Thaler?
Please, the court, Mr. Chief Justice.
Are we pronouncing that right? Is it Inglethal? Could you pronounce your last name?
Told Miss Rhoda Beck it's like a Whopper. You have to cut it in half to deal with it. Engel Thaler.
Inglethal.
Thank you.
Thank you.
I do appreciate you allowing us to be here today. I want to, first I wanted to somewhat apologize, I think, to start with. I initially filed a motion when this case was at the Court of Civil Appeals to dismiss because it was, I felt like was not a final judgment. And the Court of Civil Appeals shot back an order pretty quick, basically, that denied my motion, and they cited the Van Horn and the Van Horn case and the Gladden case, basically, and I felt like I probably should have known that, but I did not, and because it appears that those cases were primarily domestic relations type cases dealing with contempt. So when this court had that same question, I went ahead and refiled just out of safety's sake and asked that the case be dismissed for lack of a final judgment. I think that is true in this case. I know that the Wharf House case basically is what we've all traveled under, that if it doesn't completely put an end to the case, then there's not a final order that's appealable.
But don't you think because this involves a contempt issue that we can just, put a parentheses around that and let that in and of itself, because that's essentially what we've done. So I don't want to, if you're not going to concede that, I understand that. But it seems like to me, though, that when you're holding somebody in contempt and you're imposing some kind of fine or some sort of remedy on them, that in and of itself is appealable, or you may disagree.
And Judge, I don't want to disagree with you, but those cases, those particular cases, the Van Horn case, the Gladden case, and the Ezel case, those were all cases based on what I remember from reading those cases, where they were actually putting someone in jail or trying to put someone in jail in that specific instance. In this particular instance, it's not a, and there was nothing. I think in the Van Horn case, the Court of Civil Appeals basically said, well, gosh, a child support order is never really final anyway, and so that was sort of why I felt like sort of why they went ahead and went into that case with when it never really a final order anyway, and they were looking at putting the man in jail, and I believe they did put the man in jail, and the father in jail in that particular case.
Let me maybe try it this way then. We've basically got a contempt, and the remedy for the contempt, as Justice Cook pointed out, is basically ejecting from the property, and apparently there may be some other things. So doesn't that scenario seem like it would be appropriate for an appeal to lie versus letting these counterclaims get litigated and then having to go back and maybe adjust things and several more years passed by?
Well, I really think that it would have been better had it would be better for the court systems to not consider that a final judgment in this particular case, and then allow the cases to go on, because the fact that Ms. Coan was no longer has possession has no effect on her her counterclaims and the things that she's claimed in her complaint or her defenses, and it was just, I believe that Judge Self, basically the trial court, considered this as just a sanction for her willful failure to comply with the court's orders. This is really kind of a...
And Mr. Lay has propositioned to the court that there's no evidence that this was willful, and you just used the word willful.
I think if you read the transcript, there was quite a bit of evidence that it was willful. She testified that she was making $20 to $27 an hour, and she could work up to 12 hours a day. And there was a lot of testimony that I felt like during the course of that hearing that the court could look at and say that her testimony was contradictory and that her conduct was willful.
Okay, I'm going to ask you a question that has been posed to opposing counsel as well. What is the remedy in this case?
Well, and I think I hope I somewhat addressed that in my brief, that I'm not sure I know the remedy, because, and that is one reason why I also argued that I thought that it was moot in this case. My clients are they purchased it at an online auction. They purchased this house at an online auction, and they are the record title owners of the property at this point. And to take the property back away from the record title owners of the property and give it back to someone who's a holdover possessor, I just don't see how that...
Can I ask you, Mr. Engelthaler, just somewhat traveling along some of these same lines, but not to just play got you, but I do have a serious question on this. But you agree that basically, in substance, you did file a petition for contempt. Are we in agreement that's what we're calling this? Or?
I did do that, Judge.
Okay. Did you pay a filing fee?
Did I pay a filing fee? No, Your Honor.
Okay. Because our court recently, Justice Shaw wrote an opinion of the court, Ex parte Southeast Holdings, 2021, and it cited opinions of this court and the Court of Civil Appeals going back for 40 years. That is jurisdictional, the payment of a filing fee on a contempt petition.
Well, Your Honor, I felt like the court would have general supervision over the case that was there. We asked as a part of the as a part of that particular case to order to require her to pay, and I don't think I called it rent necessarily.
I searched. We had a 6-volume record, which I thought when I started preparing for this is just enormous for what is, while admittedly an adversarial and important issue, a very limited issue, and then trying to pilfer through that record over many documents I think we would all concede aren't relevant to these issues, trying to find whether the fee was paid because, and again, this court and the Court of Civil Appeals have established that you need to pay the filing fee on a contempt petition, and the clerk should designate that as a separate proceeding, which wasn't done. We got the entire record up in this case, which maybe travels along with some of the finality concerns or whether this is injunction, but again, we recently held, and it was a civil case, not a domestic case, the court, Ex parte Southeast Holdings, that failure to pay the filing fee for the contempt petition is jurisdictional. So, anyway, all right. Thank you.
So is there a trial date set in this case?
Judge, my recollection was that when Mr. Lay filed the notice of appeal, he basically informed the court that he could not go any further and that the judge did stay any further proceedings regarding this. So there was a trial, there was a summary judgment, there were summary judgment motion pending, And there was also a trial date, and I believe it was September of.
The summary judgment motion has been filed,
Summary judgment motions have been filed, and
and has there been a response filed?
there were responses filed.
But been no hearing yet on
There's
that.
been no hearings or no argument.
Did the judge enter an order staying the case? Because I couldn't find that in the record.
I didn't hear, I'm sorry, I didn't.
Did the judge enter an order staying the case? Because I didn't see that in the record. I didn't know if maybe it just didn't get put in there.
I thought that was the case, but whether he did, I can't tell you that he entered an order actually staying it, but I do know that he felt like that it was stayed and wouldn't go any further with anything. Wow.
So if, I'm just thinking out loud here, if conceptually you went to trial and lost, let's just say, okay, and there was some defense that Mr. Lay has, and conceptually you lose at trial, the trial judge is going to have to dispossess your client of the property at that point if you lost at trial.
I believe if the court held that there was that she was the record title owner, that
There was something wrong
point,
that avoided the foreclosure, for instance. They did, that the foreclosing party didn't actually have the assignment of the note, or they didn't give the proper notices under the mortgage and those sort of things. So conceptually, the trial judge or the jury could decide this was an improper foreclosure and void the foreclosure. Your client then has no, your client then is no longer the deed holder, and you can't have possession of the property. You've got to give it back to the plaintiff, I'm sorry, the mortgagor.
correct.
And would you agree that you would owe mense profits, rent, for the time that you have possession of the property improperly?
Well, potentially, I think that would be a possibility. Yes, sir.
So that's one way for us to handle this, is to send this back to the trial judge and say, have a trial, and if it turns out that you have improperly had possession of the property, you owe rent for the time you had the property.
I think that's exactly right, and I think that's why I think that's why this court should, number one, rule that it wasn't a final order to be appealable, or number two, that it was moot at this point. The property as it is right now is.
Is there something left for the judge to try other than the third-party claims? Is there a claim pending that would give the property back to the mortgagor?
No.
There's no claim. There's no way. There's no claim left that would give the property back to the mortgagor if you had a trial.
I think it would. I think it would potentially go back to the mortgagor as her being the record title owner of the property, if that were the ruling, and then she would probably have to file
But your client doesn't have an affirmative claim anymore because your claim's been satisfied, right? You wanted ejectment, you got ejectment. What do you have left pending in the case?
What we have left pending in the case is that Ms. Coan has also filed counterclaims against my client for basically the return of the property and for slander of title.
So you would have a trial over those counterclaims, and that could give the property back to her?
Yes, Your Honor.
So you don't have any claim then against her pending for mense profits or unjust enrichment or anything like that, or would that come after the case is finally decided?
That would come after yes, Your Honor, we do have a claim for men's profits, and we would be asking for those at the end of the case, yes, sir. And that is still pending as well.
Okay.
So which do you think this is, criminal or civil contempt?
Your Honor, I believe that this is a blend between the two, and I think some of the cases have recognized that before, that sometimes there's an overlap between the criminal and the civil contempt. I don't think that the court found her necessarily in criminal contempt. I think the court found that she basically had the ability to comply with the court's orders after the court ordered those, and that she basically had the keys to the jail in her pocket. However, rather than incarcerating her until she did that, I think the court made a reasonable sanction to dispossess her of the property.
That was a permanent disposition, right? I mean, unless she wins the trial, I guess. I mean, because she's out of the property now, how is she going to purge herself of contempt?
Well, I think, yes, Your Honor, and I think this particular case has had some very serious implications that I think you touched on, in that there's nobody paying the tax. If somebody don't pay the taxes on there, then of course, then there's another tax sale and potentially involved. There's no insurable interest at that point, and Championship, had a very difficult time, couldn't insure the property while she was a holdover possessor there, so to protect the property.
I'm sorry, so the property was bought at a county tax sale?
No, Your Honor. It was an online auction, online real estate auction.
Thanks.
And Championship is basically a bona fide purchaser for value.
Did they do any due diligence? Because it seems like to me, if you're a bona fide purchaser for value, you got to say, "What I didn't have any knowledge." And if you do a search of the record, it seems like to me you would see there's some problems because, Carrington filed an ejectment action that was out there, and if you knew about the ejectment action, I'm not sure you can say you're a bona fide purchaser for value because you would have knowledge that somebody's trying to evict a holdover tenant, right?
I don't think that they had any knowledge that there was a previous lawsuit regarding that, and that's not the type thing that would be filed in the real estate records. And I think as per the real estate records and the searches that were done on the real estate records, there was a foreclosure. The foreclosure was never attacked.
But you've got somebody that's still living in the property. I mean, it just seems like if you had a vacant piece of property, you bought it at an online auction, you could say you're a bona fide purchaser for value. But I think the without knowledge part is what maybe defeats that argument, because if you looked at any records or went by the house or did what I would consider to be minimal due diligence, you've got somebody living in the house. And so you can't be a bona fide, maybe I could be wrong, and maybe you can convince me otherwise, but if you know that there's some ongoing things with ejectment and all that, and you would search records, it's based on the person that's, part of this. I'm just trying to understand how you could really be a bona fide purchaser for value.
If you search the records, there would be nothing there is nothing in the records that would show that the foreclosure was invalid or even contested at this point.
So the ejectment would have no impact on whether you were a bona fide purchaser because if you know somebody's living in a house and you're buying it, you've got some knowledge that there's a problem, right?
I don't think so.
Okay.
That happens quite often in the real estate industry, that houses are bought and sold and mortgages are assigned and things such as that with people living in the house, and that's not a
It's a foreclosure deed, right? I mean, if it's a foreclosure deed, you know that there's somebody had the house if it got foreclosed. So you're buying an as-is deed.
Correct. It was a foreclosure deed. It was.
So I wanted to ask about the order, the show cause order the trial judge issued before the final hearing. The judge issued an order that said that she had 18 days to purge the alleged contempt or show cause or face incarceration. So he suggested incarceration in his show cause order. He didn't suggest he was going to grant default or eject her.
I think that's correct. I think I can't go into the judge's mind any more than Mr. Lay can, and as far as what he was thinking, I have no idea. I think
I'm just thinking about fair notice to her. I mean, she may have noticed that she might have gone to jail, but did she know she was going to get thrown out of her house?
Well, I mean, and I'm not sure that it was necessarily her house. I mean, she did lose it in.
Well, Mr. Lay is alleged it was her house. I mean, and he hadn't lost yet, so.
Well, I understand that argument, but I don't think that's a correct argument, because as we actually stand here today, I believe Championship Property is the record title owner of the property.
If we send it back, how fast can y'all get to trial? How fast can you have a summary judgment hearing?
I think it would probably be fairly quick. I think most of the summary judgment documents had been filed and completed.
And I'm not saying that this court will agree to that, but if they do, would it be beneficial for this court to suggest that this be done within a 60, 90-day period?
I don't see any problem with that at all. No, ma'am. I think that would be wise. Mr. Lay said to you before that we consented to the prior removal in federal court, which was correct. We did. One of the reasons, and I had conversations with my clients as well, and we thought that there were some federal issues of mortgage foreclosure, RESPA type issues that were raised in the complaint. And we felt like that probably in the federal system that the case might move on just a little quicker as well regarding those issues and things, considering there has been a lot of litigation in the federal system regarding this same thing.
I hate to interrupt you, but your time is short. So I just want to get to this point. Right now, there's an appeal that Mr. Lay's filed on behalf of his client, and it's basically told us certain things. The first thing that we've got to deal with is it appropriate for a court to require a holdover tenant, whatever word you want to use, a squatter, somebody that's living in the house, to make certain payments? I mean, that's an issue he thinks that he's petitioned us. The second thing deals with, holding her in contempt. So on those two issues, would you at least give me some idea of what you think about? Does a circuit court in Alabama have the right to require somebody in pending litigation over possessory interest to pay some form of payment to cover insurance, taxes, or whatever?
I think so. Your Honor.
Are there any cases that you've seen on that might enlighten us to help us?
I really have not found any cases that go into that, and I'm hoping this court will agree that a court could, make those type orders and determine, because we all know that houses have to be, there has to be maintenance done on them, there has to be taxes paid, there has to be insurance and things such as that, and somebody's going to have to do that, and I think the only person that can make anybody do it would be the court. I don't know who else could provide those safeties, and it's a safety for both of them, for both parties in this case. I think Miss Coan testified. I asked her. I said, "Well, what happens if something happened to the house?" And she said, "Well, I guess it'd just be gone." Well, by requiring the parties to make a payment into the court for general things such as that, not only is it appropriate, I think it's necessary. And I know I'm on a red light, and appreciate it, and if there are no other questions, I'll,
Thank you, Mr. Engelthaler.
thank you.
Mr. Lay?
Thank you again, Your Honor. Three things I want to address. I had time to think about your question. I don't think we have waived anything regarding the preliminary injunction, and here's why. If you go and look at the Ex parte Ferguson case, and maybe the original order may be a problem, but as to contempt, the first question on a contempt is the order legal and valid? And we argue it isn't. So for purposes of this appeal, I don't think we have waived anything as it relates to that. Secondly, to answer Justice Sellers, your question about why can't the courts do this, they elected to go under a statute, 66280. It provides a remedy of the mens rea profits, and he's conceded that. So, all we ever hear is, well, it's equity, it's not fair, it's this and that, and I get that. But the statute is very clear, and this court made very clear in the IVF ruling recently that even if it's a bad public policy, or regardless of the ramifications, it's not the court's job to fix bad policy or fix problems that have come along. It's the legislature. They elected to go under a statute. There are other remedies. You can do common law ejectment. They didn't choose that. So they chose 66280. It's the statute. It's very clear. It provides a remedy. What is this? And there's no case law that says that.
So just to follow that further, so what your argument is basically, once you go for this statutory ejectment, I'm going to call it, a circuit court, general jurisdiction court in Alabama has no ability to enter an order to require interim payments to cover taxes, insurance.
That is absolutely correct. And remember, this wasn't for taxes and insurance. And it's not true. And I know Judge Cook used to do some of these cases.
Were taxes and insurance taken out of the mortgage?
They were in the escrow.
And it does include taxes and insurance?
No. What I'm saying is the order from the trial judge was not for taxes and insurance. It was just purely a rental payment.
Did your client pay taxes and insurance?
No. And number one, they cannot.
That's not a very good argument.
Well, I agree it's a problem, but it's a legally correct argument, Justice Brown, because the insurance companies will not allow someone, whenever there is a foreclosure deed, immediately upon an insurance company finding out that there has been a foreclosure, they end the insurance. So my client no longer had an insurable interest. It is upon the bank or whoever takes over to insure the property. They're the only ones with an insurable interest at that point. So she couldn't have insurance on it.
They couldn't get it either.
Well, they could have. We do these cases all the time. I've never heard before. It is a problem, and it may cost more, but they definitely could have gotten insurance. If they didn't elect to do that, then that's on them. I have hundreds of cases going on right now where every single one of them has insurance on it.
So if she doesn't have an insurable interest, then what interest in the property does she have, and how would you quantify what she has?
According to the statute and the case law, she has a possessory interest pending her claims regarding the foreclosure.
A possessory interest, you can't get insurance to cover.
No, sir. You can get what they call a renter's policy or a contents only, but you cannot insure the structure. I promise you, and if you want supplemental authority on that, I'll be happy to do it. But I just want us to remember that if we deal with the real this case is a mess, and there's lots of questions, and it's difficult. But if you look at the underlying issue, which started the whole thing and created the mess, and this isn't the only messy case we have like this. This is the first one you all have entertained, but it becomes a problem when these kind of orders are entered. And the truth is, it's really an end-around way of a gotcha game. Every single case that I have had, this is the first one has ever gone this far. Most of the time, the banks withdraw their claims. I've had 3 appeals up here where they withdrew. Even when the court had entered an order allowing for these payments, they withdrew it and gave it back. It's never about them paying. It's a strategy to hope that they can't make a payment, and then you can run to court and get the result they want quicker and easier. That's really what this is about. It's always been about that.
I would probably
Mr.
disagree
Lay,
with you on
I
that,
would
but
disagree with you on that. I think it's about somebody not paying what they've promised to pay.
And that is true for the foreclosure itself, but it's not. What I am saying, and I don't want to get off on the wrong foot, but what I'm simply saying is the reason that these orders are sought and the reason that these contempt petitions or whatever you want to call them are found is to get the result that they got. It was never about making her pay a mortgage, which she couldn't do anyway. And there's plenty of evidence of that in the other cases where they just withdraw the claims and never pursue it.
do you have any answer for us on what you think the remedy should be if we reverse this order of contempt? What should happen next?
I think that the order should be reversed, that it wasn't properly done for several reasons as we've cited, and the result should be that she should be put back in the property pending the resolution of the case.
We should take possession away from the holder of the deed and give it back to her. That's what you want us to do.
Well, that is what the pending claims are. That is, I mean, I'm not telling you, I mean, obviously I can't make you do anything, obviously, but I mean, she was fighting for possession of the property, and we feel we do have valid claims, some of which we mentioned in the briefs.
If she wins the lawsuit, she's going to get possession, right?
Well, the other alternative is that they will owe her money, which is what I put in the letter to her.
Right.
If, because like I said, because of the mess right now, I'm not sure they can give it back to her. I'm not sure that is a remedy anymore because of what has transpired since then. I think now she's probably stuck with whatever monetary damages she can get for the improper set out.
Would she have the ability to pay if she was back in the home? Or are we going to end up here 3 months from now on the same thing?
All I can,
Not here, but
yes,
locally.
ma'am. Justice Wise, I can't.
And that's not in the record. I mean, it's not in the record, but you had
I
made
mean,
the statement
what
she did
said
not
at
have
the
the
hearing
ability
and
to
what
pay.
she has told me, that's all I can speak for, is that she was never trying to not pay. She wanted to pay. She was willing to do that. She repeated that over and over again, but she did not have the money at the time. Now, whether or not she can pay now, I'm assuming that she could pay something, but I don't know for sure.
She's in the house now. She's got a place to live, right?
Well, she was living in a car for a while, and her kids got taken away by the father over this, but she is back. She's living with some relatives now.
Mr. Lay, thank you so much. Unless the court has any more questions, we appreciate it very much. And
Thank you, Justice Shaw.
we thank counsel on both sides for their arguments, and this case will be submitted. And court is now adjourned, and we do, again, welcome all of our special guests. We see a lot of young faces out there. Thank you for attending this oral argument. Court will be adjourned.
All rise. The court is adjourned.